On my daughter's birthday, my son-in-law sat across from me at the dinner table and said, "Dad, is the $6,500 my wife transfers you every month covering your prescriptions okay? We can send more if you need it." I set down my fork, looked at him, then at my daughter. "What transfer?" I said. "Son, I haven't received $1 from either of you. Not once." The table went quiet in a way that felt different from ordinary quiet. My daughter, Isabel, was already staring at her husband. Her face had gone the color of old dishwater. And her husband, I'll call him by his name because he deserves to have it attached to what he did. Marcus looked down at his wine glass and said nothing for a very long time. That was the beginning of it. Though the stealing had started 3 years earlier. I should tell you a little about myself before I go further, because it matters to understanding what came next. My name is Harold. No, wait, that name's been used. My name is Kenneth. Kenneth Breyer. I spent 31 years as a forensic auditor for the Canada Revenue Agency in Ottawa, and before that, I worked private audit for 2 firms in Toronto. Numbers were never just numbers to me. They were stories. Every ledger tells you something about the person who kept it. Every transfer, every gap, every rounded figure where a precise one should be, all of it speaks, if you know how to listen. I retired at 64 with a pension that covered the basics comfortably enough. House paid off in Kanata, a quiet suburb west of Ottawa, the same house where I raised Isabel after her mother passed from ovarian cancer when Isabel was 19. Just the 2 of us for years. We were close in that particular way. You become close when grief strips away the formalities. When Isabel married Marcus Vance 6 years ago, I tried to like him. He was charming the way certain people are charming, effortlessly, and with a slight undercurrent you couldn't name but could feel. Like a draft under a door. He worked in commercial real estate development in Toronto, made good money, drove a car that cost more than I earned in my last 3 years of work combined. I told myself I was being a protective father and let the feeling go. They settled in Toronto, 3 hours away. I visited 4 or 5 times a year. They came to Ottawa for Christmas and occasionally Easter. When I had a minor cardiac event 2 winters ago, nothing dramatic, a warning for my body to slow down, Marcus was the one who suggested setting up a support arrangement. "You shouldn't be worrying about prescription costs on top of everything else," he told me over the phone. His voice was warm, concerned. "Let us take care of it. Isabel and I want to help." I told him I didn't need charity from my own daughter. He called it family support, not charity. Said Isabel felt terrible that I'd been managing alone. Said they'd set up a direct deposit, nothing complicated, just a monthly transfer to ease the burden. I said I'd think about it. A few weeks later, Isabel called and asked me the same thing, more gently. She sounded like she meant it. I agreed. And then nothing arrived. I assumed there had been a delay, a mix-up. I was embarrassed to call and ask. I had my pride, which is a thing that costs you more than it saves, I've learned. I told myself if it didn't come by the following month, I'd say something. Then another month passed. Then I stopped counting because counting felt humiliating. I applied to the Ontario Seniors Dental and Drug Program for help with my cardiac medications. I adjusted my grocery budget. I sold the second car I didn't really need. I told myself I was managing fine and almost believed it. 3 years of that. And then my son-in-law sat across from me at Isabel's 42nd birthday dinner at their Toronto townhouse, marble countertops I'd heard described at length, a kitchen renovation that apparently cost more than my first mortgage, and asked me if $6,500 a month was enough. After Marcus said nothing for too long, it was Isabel who spoke first. She put her hand flat on the table the way she used to as a child when she was frightened. "Marcus," she said. Just his name, quietly, like a door closing. He looked up from his wine glass. "It's complicated," he said. Those two words. I worked in audit for 30 years. I know what complicated means when a man says it about money that isn't where it's supposed to be. Isabel's eyes came to me. She had her mother's eyes, dark brown and very direct, and right now they were asking me something she didn't know how to say out loud. "How long have you been sending it?" I asked Marcus. "Since we agreed to," he said. 3 years. Every month. To what account? He told me the name of the arrangement. A support account he'd set up through their financial planner, a man named Simon Greer from a firm on Bay Street. The account was in my name as the beneficiary to receive structured family assistance payments. For tax purposes, Marcus said, Simon handled the administration, made it cleaner. I had never spoken to Simon Greer in my life, never signed a document with his firm's name on it, never received a statement. The silence at that birthday table was the kind that ages a room. "I want to use your bathroom," I said, and stood up. I walked down the hall, past the framed photographs of their wedding and their ski trip, to Whistler and their anniversary dinner in Montreal, and I stood in their immaculate bathroom with my hands on the cold sink and breathed. In through the nose, 4 counts. Out through the mouth, 6. Cardiac rehab breathing. I'd learned it the winter of the heart event, and I used it whenever I needed my brain to work instead of my emotions. $234,000. That was the rough figure. 36 months at $6,500. I didn't reach for my phone to calculate it. I did it in my head before I turned off the bathroom tap. When I came back to the table, Marcus was speaking in a low voice to Isabel. He stopped when he saw me. She was crying, silently, in the way she'd learned from watching her mother be sick, keeping the sound inside, letting only the tears out. I sat down. "Marcus," I said, "I'd like Simon Greer's contact information." He said Simon was hard to reach on weekends. I said that wasn't what I'd asked. He gave me a number, slowly, the way you give someone something you wish you could take back. That night I slept in their guest room, Isabel insisted, and I didn't have the energy to drive back to Ottawa in the dark. And I lay on their guest bed with my phone on my chest and thought about fires. My late father was a firefighter in Kingston. He used to say that a fire always tells you exactly what happened if you're willing to read what it leaves behind. Burn patterns, accelerant traces, the shape of the char. The truth is always there in the evidence. It doesn't hide. It just waits for someone who knows how to look. I knew how to look. Monday morning I called Simon Greer from my kitchen in Kanata. He answered on the second ring, which surprised me. Professional voice, mid-40s by the sound of it. When I gave him my name, there was the briefest pause, the kind that lasts less than a second, but might as well be a flare going up. I told him I was calling about the support account in my name. He told me he'd need to verify my identity before discussing any accounts. I said, "You can verify. And then you can tell me why I have never received a statement, a phone call, or a single deposit notification from an account that lists me as the beneficiary." Another pause. Longer this time. He told me the account structure designated the fund manager, Marcus Vance, as the controlling party, that I was the named beneficiary but had no direct access. That statements went to the controlling party for administration. I asked him, very calmly, who had actually received the disbursements from this account over the past 3 years. He said he wasn't able to share that information without the controlling party's consent. I thanked him politely and hung up. Then I called my daughter. She answered on the first ring. She'd been waiting. I could tell by the sound of her breath. "Isabel," I said, "I need you to send me every bank statement, every transfer record, everything Marcus has related to that account. I need it today." She said she'd been trying to get into his home office files all morning. He'd changed the password on his laptop overnight. That told me almost everything I needed to know. I drove to Ottawa Public Library on Metcalfe Street and used their printer because mine had been out of ink for 2 months and I hadn't bought a new cartridge. 7 cents a page. I printed the 3 pages of notes I'd made the night before, my pension statements for the past 3 years, and the paper trail I'd started building from memory. Time deposits from the CRA, OAS, supplements, the drug program assistance records. A record of everything that had come in, and the notable absence of anything from a Bay Street financial firm. Over the next 4 days, I built the case the way I would have built an audit file. Isabel got into Marcus's email. She knew his secondary password, the one for their joint accounts, which he'd forgotten to change, and forwarded me 6 months of correspondence with Simon Greer. I spread them across my dining room table and read every one. The pattern emerged like a water stain through plaster. Slow, then impossible to ignore. The support account had received 36 deposits of $6,500 each, $234,000, exactly as I'd calculated. Of that amount, a total of $0 had ever been dispersed to me. The disbursements went to 3 places: a private account in Marcus's name at a different institution, a numbered company registered in Alberta Shell Company, obviously. I could see the structure from the naming convention alone, and a third account I couldn't identify from the email trail alone, but which appeared in the correspondence as the RV account. I sat with that for a while. Then I called a lawyer. I'd never needed a personal lawyer in my life. I'd worked alongside Crown Counsel and corporate legal teams for decades, but I'd never had cause to hire one for myself. I asked my former colleague at CRA, a woman named Judith who'd retired 2 years before me and now volunteered at a seniors advocacy center in Centretown, if she knew anyone in Ottawa who handled financial fraud in family matters. She gave me the name of a lawyer named David Okafor, who had an office on Somerset Street West. She said he was sharp and that he didn't talk down to clients. That last part mattered to me. I met David the following Tuesday. His office was small and deliberately unimpressive. No marble, no credentials framed in gold, just organized file stacks and a good lamp and a man who read my documentation with his full attention for 20 minutes before he said a word. "You've done half my job already," he said, flipping back to my summary spreadsheet. 31 years at CRA, I said. He almost smiled. "I'm going to need your pension statements, the email correspondence, your drug program assistance records, and anything your daughter can access from the account structure. Can she get the original setup documents from the financial planner?" "I'll ask her." "Good. And Mr. Breyer, has your son-in-law contacted you since Saturday?" "Not directly. He sent me a text on Sunday saying he could explain everything and asking me to call him before involving anyone else." David looked at me over his reading glasses. "I didn't respond," I said. He nodded. "Don't." "Not yet." Isabel found the set of documents 3 days later in a folder Marcus had labeled tax planning, in a filing cabinet she had full legal access to as joint owner of their home. She photographed every page and emailed them to David. The account had been established in my name without my signature. Instead, Marcus had used a document he'd had me sign 2 years earlier, which he'd told me was a consent form for the drug benefit coordination he was supposedly arranging on my behalf. I'd signed it without a lawyer reviewing it because I trusted my daughter's husband. I remembered signing it. A single page. He'd brought it to Ottawa one Sunday afternoon, set it on my kitchen table beside my coffee, pointed to the signature line. I'd read it, but not carefully enough. The language was constructed to look like a routine consent authorization and function as something else entirely. 31 years auditing tax fraud, and I'd been taken in by my own son-in-law at my kitchen table. I won't pretend that didn't sting. David filed the civil claim 3 weeks after our first meeting. Unjust enrichment, constructive fraud, breach of fiduciary duty. The claim named Marcus Vance and Simon Greer jointly, detailed each of the 36 transfers, and sought $234,000 principal plus interest, calculated under Ontario law, plus legal costs. The night the papers were served, Marcus called me. I let him talk for a while. He was angry at first, then he pivoted to wounded, then to something harder to categorize. A kind of flat, cold reasonableness that I recognized from audit interviews with people who'd been cornered. He said I was destroying his marriage. He said Isabel would never forgive me for dragging her family through court. He said I'd misunderstood the account structure, and if I'd just let him explain it in person, we could resolve this quietly. Marcus, I said, I spent 3 years buying generic prescriptions because I thought my pension wasn't covering them. I spent 3 years not putting the heat past 68 degrees in January so I could pay my property tax on time. I applied to a government assistance program because I believed my daughter and her husband had decided not to help, after all, and I was too proud to say anything. I paused. I don't think you've misunderstood me. He hung up. He called back 11 minutes later to tell me I would regret this. I recorded that call, as was my right under Ontario law, which requires only one-party consent for recording. I sent the file to David before I went to bed. The next few weeks were unpleasant in the way that slow processes always are. Not dramatic, just grinding. David's discovery requests went out. Marcus retained a lawyer from a Bay Street firm which told me he was worried. Simon Greer retained a separate lawyer almost immediately, which told me even more. When co-conspirators lawyer up separately, they're preparing to protect themselves from each other, not just from the plaintiff. Isabel was caught in the middle of all of it and handling it badly, which I understood. She loved her husband. Or she had loved him. I wasn't sure anymore what she felt. She called me every few days, sometimes to update me on what she'd found in his files, sometimes just to cry. I listened. I didn't tell her what to do. She was 42 years old and she had to find her own way through this. What I did tell her, whenever she started blaming herself, you trusted your husband. That's not a failure of judgment. That's what marriage is supposed to be. In February, David deposed Simon Greer. The transcript arrived in my inbox 3 days later, and I read it at my kitchen table with my morning coffee. Greer had constructed his defense carefully. He claimed Marcus had represented himself as having power of attorney for my financial affairs, a claim that was false but not easily disproved without the original documentation, which was why the signature-forged consent form mattered so much to our case. But Greer had kept records, meticulous records actually, the kind of records that a Bay Street financial planner keeps because he's terrified of regulatory audit, not because he has a conscience. Those records showed every transaction, every communication, every instruction from Marcus about where disbursements should go. The RV account, it turned out, belonged to Marcus's brother, Raymond Vance, who lived in Calgary. Raymond had received $41,000 over 3 years in transactions labeled consulting fees. Raymond had no consulting business. Raymond was a high school gym teacher. I actually laughed when David told me that. Not a mean laugh, just the particular laugh that comes when a financial fraud turns out to be both worse and more stupid than you expected. In March, Isabel told me she was filing for divorce. She called from the driveway of their Toronto townhouse at 9:30 on a Tuesday evening, sitting in her car in the dark. I could hear the engine ticking as it cooled. She said she'd been to see a family lawyer that afternoon. She said she'd been deciding for 6 weeks, and she'd stopped deciding. I asked if she was okay. She was quiet for a moment. Then she said, I feel like I'd been living in a house I didn't know the real address of. I told her that was a very precise way to describe it. Dad, she said, I'm sorry. I'm so sorry I didn't know what he was doing. Isabel, I said, you couldn't have known what he was hiding. But you helped me find it once you did. That matters." She cried for a while, and I stayed on the line. There was nothing else to do, and it was the right thing. The civil hearing was scheduled for April in Ottawa, Judge Anuradha Mehta presiding, a former Crown attorney with a reputation for impatience with evasion. David had warned me she wouldn't be charmed by Marcus's manner. I considered that a good sign. I wore the suit I'd bought for my retirement luncheon from CRA, navy blue, slightly loose now. I sat in that courtroom the way I'd sat in budget review meetings for 30 years, straight, hands folded, paying complete attention. Marcus's lawyer argued that the account structure had been established with my informal consent, that the arrangement was a discretionary family fund rather than a designated support transfer, and that my claims misrepresented the nature of the agreement. David presented the documentation. The consent form I'd unknowingly signed compared against the account structure it had been used to establish. Simon Greer's transaction records. The drug program assistance applications I'd filed, time-stamped during the same period the supposed support payments were being made, evidence that I had not in fact been receiving any financial help from family during those years. Marcus's email correspondence with Greer, including one message from 16 months ago, in which Marcus wrote, with a casualness that still makes my jaw tighten when I think about it, "Don't worry about statements. The old man doesn't check email regularly and wouldn't know what he was looking at anyway." I had worked in financial audit since 1989. I had caught people hiding $12 million across 6 jurisdictions using 4 shell companies in a Liechtenstein trust arrangement. I did not make mistakes with numbers. Judge Mehta questioned Marcus directly for 40 minutes. By the time she finished, his lawyer had stopped taking notes and started staring at the table. David called me the evening after the second hearing day. He said Judge Mehta had issued an interim order freezing Marcus's personal accounts and the numbered Alberta company pending final judgment. He said he expected a ruling within 6 weeks. The ruling came in 5. I was sitting on my back porch in late May when David called. Ottawa spring comes late and uncertain. There had been frost 2 nights earlier. But that afternoon the sun was low and warm, and I'd been watching a pair of chickadees work over the suet feeder I'd put up that morning for the first time in years. I'd let the yard go during the harder months. Hadn't had the heart for it. David's voice was measured and satisfied, the way a careful man sounds when something has gone exactly right. "We got everything," he said. "Total judgment, $234,000 principal, $21,000 interest, $11,000 in court costs and expert fees, $266,000 in total. Simon Greer was found jointly liable for the portion disbursed through accounts he administered, which amounted to $63,000. Marcus bore the remainder." The counterclaim Marcus had filed defamation and emotional distress, claiming I'd damaged his professional reputation and his marriage by pursuing legal action, was dismissed entirely. The judge's written reasons noted that the counterclaim appeared designed to pressure a withdrawal of the primary action rather than to address any genuine harm. I sat on that porch for a long time after David hung up. The chickadees kept working at the suet feeder. A neighbor's lawnmower started up somewhere down the block. Ordinary Tuesday afternoon. I thought about the winter I'd kept the heat at 68 and told myself I was fine. About standing in line at the Service Ontario office to apply for the drug benefit program and hoping I wouldn't run into anyone I knew. About signing a piece of paper at my kitchen table because I trusted my daughter's husband. None of those things felt distant yet. I suspected they wouldn't for a while. The court ordered seizure of Marcus's personal accounts. There was $140,000 in a checking and savings combination at TD, frozen immediately. The numbered Alberta company had assets of $68,000, seized and transferred to court control. The remainder came from the forced liquidation of what his lawyer had, during proceedings, repeatedly described as personal investment items. A watch collection Marcus had assembled over several years, sold at auction through a Yorkville estate house for $41,000. Various brokerage accounts made up the balance. Raymond Vance, the gym teacher brother in Calgary, was separately advised by CRA that $41,000 in undeclared income would require attention. David had quietly filed a referral. That wasn't part of our civil case, but it seemed correct. Isabel's divorce was settled in July. The prenuptial agreement Marcus had insisted on. At the time, she'd thought it was a reasonable precaution for a man with significant assets. It now appeared in a different light. Protected his pre-marriage real estate holdings. But the fraud judgment was part of the public record, which complicated any asset claims he tried to make. He received a settlement Isabel's lawyer described as adequate and unchallenging. He kept his car. He kept his condo in Yorkville. He lost everything else worth having. The first payment from the court-ordered disbursement arrived in late July, $140,000 deposited to my account on a Thursday afternoon. I was at the Rado Center buying a new winter coat, the first one in 4 years, when my banking app sent the notification. I stood in the men's outerwear section of Hudson's Bay and stared at my phone screen for a long moment. Then I bought the coat, a good one. Wool and cashmere blend, charcoal gray, the kind that lasts 20 years if you take care of it. $480. I paid without hesitating, which was a feeling I hadn't had in a long time. I had specific plans for the money. I'd thought about them carefully over the months of the legal process, in the way I'd found it easier to think about the future outcome than about the daily frustrations of the fight. I updated my will with a family law notary, Margaret Liu, who had an office in Westboro. My house would pass to Isabel through a trust structure that protected it from any future claims by creditors or former spouses. The bulk of the recovered funds, after legal costs, which came to $38,000 in total, would go into a registered education savings plan for my granddaughter. She was 4 years old. Isabel had been pregnant when the Thanksgiving birthday dinner happened, though I hadn't known it that night. She'd told me 3 weeks later during one of our phone calls, and her voice had a particular quality, relief and terror in the same breath, that I recognized as the sound of someone who just decided to stop being afraid. My granddaughter's name was Maeve. I'd met her twice before the legal proceedings began and watched her grow through photographs and video calls during the months I was too absorbed in documents and court filings to visit properly. When everything was settled, Isabel drove up to Ottawa with Maeve in August for a long weekend. Isabel looked different from how she'd looked at that birthday dinner. Lighter in the shoulders, somehow, like she'd put down something heavy and was still getting used to walking without it. Maeve was one of those children who treats unfamiliar adults with a calm assessment as someone who has encountered many things and found most of them manageable. She studied my living room for about 45 seconds, identified my bookshelf as the most interesting feature, and went to investigate it. I let her pull out whatever she wanted. She selected a field guide to Canadian birds published in 1987 and carried it to the couch with great seriousness. We spent Saturday afternoon at the Canadian Museum of Nature on McLeod Street. Maeve had views about the dinosaurs, strong, specific, confident views. She told me the names of several species with the tone of someone correcting a common misconception. I told her she was right about all of them, which she accepted without surprise. That evening, on the front porch, while Maeve slept inside and Isabel sat with her tea and I sat with mine, we talked for a long time in the way we hadn't been able to talk for almost a year. About her mother, Isabel's, and how she would have handled all of this. About the house and whether I should think about downsizing eventually. About Maeve and what kind of world she'd grow up in and what we could do to make sure she grew up in it, knowing what her family was worth. "I want her to know you properly," Isabel said, "not just on a screen." "Then bring her more often," I said. She laughed, for the first time in a long time, really laughed, and it sounded like her mother. On Sunday morning, I showed Maeve how to use my old Bushnell binoculars from the porch. She could barely hold them steady, but she didn't want help. She was very interested in a blue jay in the spruce tree across the street and demanded a detailed explanation of why it was that particular color. I told her it was a structural thing, light bending through the feather structure rather than pigment, and she considered this information for a moment with the expression of someone deciding whether to accept it. "Like a prism?" she said. She'd learned about prisms somewhere. She was 4. "Exactly like a prism," I said. When they drove away Sunday evening, I stood at the end of my driveway until the car turned at the bottom of the street. Then I went inside and made myself dinner and ate at my own table in my own house in the particular quiet that means safety rather than loneliness. The respects account for Maeve would hold, by David's calculations using conservative projections, somewhere in the range of $450,000 by the time she finished a graduate degree, if she chose one. Enough to give her choices. That's all education is, really. The accumulation of choices, the ability to say yes to things and no to things from a position of actual possibility rather than constraint. Marcus had meant the money to furnish a life of acquisition. It would instead furnish a life of learning. I found that satisfying in a way that had nothing to do with revenge and everything to do with completion. I don't think about him often. When I do, it's briefly and without much feeling. He's living in the Yorkville condo, I understand, and working in commercial real estate still, though at a smaller firm. The fraud judgment follows him on record. It will complicate certain professional registrations, certain client relationships, certain background checks for as long as it remains on file. That's not something I arranged. It's simply consequence. Doing what consequence does. My heat is set to 71 this winter. My prescription copays come out of a dedicated account I set up in the autumn, fully funded, no guesswork. The new coat is hanging in my front closet. I'm going to Isabel's for Christmas. Maeve has requested that I bring the bird book. I intend to. I think about that birthday dinner table sometimes. The quiet after Marcus said, "It's complicated." The particular stillness of a room where everyone suddenly understands something they can't yet say out loud. What I keep coming back to is not the money. The money was recoverable. What isn't so easily recovered is the 3 winters I spent telling myself I was managing fine, turning the heat down, skipping the name-brand prescriptions, standing in that Service Ontario line, hoping no one I knew walked past. That was the real cost of what he did. Not the number on a court order, the daily, quiet erosion of a person's dignity when they believe they've been forgotten by the people who love them. Marcus counted on me being too proud to ask questions. He counted on the assumption that an older man living alone wouldn't scrutinize what he couldn't see. He built his scheme on the idea that I was, as he wrote in that email, someone who wouldn't know what he was looking at anyway. That calculation was both the foundation of what he did and the reason it unraveled. Because the same habits of mind that kept me from asking for help, the precision, the patience, the refusal to let a discrepancy go unexplained, were exactly the habits that dismantled everything he'd built. There's a kind of cause and effect in life that doesn't require anything mystical to explain. It's just the plain logic of actions and their consequences. Marcus spent 3 years taking what wasn't his, and the record of every transaction was preserved in exactly the kind of documentation a Bay Street financial planner keeps to protect himself from regulatory scrutiny. He underestimated me, and he underestimated the paper trail he'd created. Those 2 miscalculations were enough. What I know about the people who came through this well, Isabel most of all, is that they held on to something essential under real pressure. Isabel had every reason to protect her marriage, to find a way to explain away what she was finding in those files. She didn't. She chose what was right over what was comfortable, and she did it knowing it would cost her. That's not a small thing. That's the kind of integrity that doesn't announce itself. It just shows up when it matters and does what needs doing. And then there's what got me through the months of hearings and depositions and counterclaims and the slow grind of waiting for a ruling. It wasn't anger, though I had plenty of that in the early weeks. It was the discipline of staying methodical, building the case one document at a time, not letting frustration push me into shortcuts. 31 years of audit work had given me that, and I used every bit of it. The strength that carried me wasn't physical. My heart had been telling me to slow down for 2 years by then. It was the kind of steadiness that comes from deciding quietly that you will not quit before the work is finished. Maeve asked me last month why the blue jay is blue. She's 4 years old, and she already knows the word prism. I thought about that for a while after she and Isabel drove home, about what kind of person she might become, and what I want her to understand about how to move through the world. I want her to know that being honest with herself and with others is not a personality trait, it's a practice. I want her to know that thinking carefully and precisely is something you can build, one problem at a time, the same way I built that audit file on my dining room table. And I want her to know that when the ground shifts under you and the people you trusted turn out to be something other than what you thought, you don't fold. You breathe, you document, and you keep going. The respect account in her name will be worth something real by the time she needs it. But what I hope matters more is that she'll know where it came from and why.